Hey there, and welcome to Beyond Borders, the Immigration Evaluation Podcast. If you're a mental health professional looking to expand your practice and make a meaningful impact by conducting immigration psychological evaluations, you're in the right place. I'm Dr. Mariella Shibley, and on this podcast, we dive into the ins and outs of conducting immigration evaluations, helping you grow your practice while helping families stay together. So let's get into it. Hi, everyone, and welcome back to the podcast. I want to tell you about something that happened recently during one of my evaluations and why it's a great reminder of how important it is to really understand the immigration processes behind the cases that we work on. So here's what happened. I had an evaluation the other day for a U visa. So the person called, told us which attorney referred her, said it was for a U visa, and scheduled the evaluation. So pretty straightforward. Now, if you've worked on these cases before, you know that a U visa is usually focused on assessing the extent of the harm the person suffered as a result of a qualifying crime. What they need to demonstrate to USCIS is that the harm was substantial. Now, of course, substantial is a pretty vague term. It's not like there's a formula for what counts, but the goal is to paint a clear clinical picture of how the crime impacted the person's psychological functioning. So this woman sends us the police report, her written declaration, everything checks out, we're good to go. She shows up for the evaluation. And one of the first things that she tells me is that she needs the report within 1 week. So now I get it, people want to file quickly, and there is a sense of urgency, whether it's due to legal timelines, anxiety, or other pressures, but reality is that as far as I know, there is no actual rush with a U visa. These cases are just so backlogged that it could take over 10 years before USCIS gets around to adjudicating that petition. But hey, if she wants it fast, we'll do our best, so we start. So I begin with her background, asking about her childhood, her family, any history of trauma. I'm trying to assess her personality, her vulnerabilities, anything that might predispose her to suffering more than the average person in response to a similar trauma. And sometimes this comes in handy when trying to explain why the harm was particularly substantial for this individual. Even though I don't word it that way, this is the information that I like to present. So then all of a sudden, sort of like offhandedly, she mentions that she was arrested for a DUI. And this was about 20 years ago. She's now 45 years old. And I'm like, wait, arrested? Like actually arrested and taken to jail? And she says, yeah, but it was a long time ago. So she explains that she was going through a really difficult time emotionally after a breakup. She went to a friend's house, had some wine to drown her sorrows, and then decided to drive home, which was just a few blocks away, so it was a dumb mistake. And so she was pulled over, arrested, and that was that. So then I ask her, does your attorney know about this? And she says, oh, yeah. So now my wheels are turning, right? So I'm thinking, she wants a rush evaluation. She has a DUI on her record. And I'm starting to wonder, is this evaluation really just to assess the impact of the crime against her? Or is there something else going on? And then it clicked on me. This might not be about proving substantial harm at all. This might be about overcoming a ground of inadmissibility. So if you're familiar with immigration law, you know that there are several reasons why someone might be found inadmissible to the United States. That means that they wouldn't be allowed to enter or remain in the country, even if they meet all the other eligibility criteria for the visa or the benefit that they're applying for, because of a number of reasons. So some common grounds of inadmissibility include immigration fraud or misrepresentation, security-related issues, previous removals or unlawful presence, or having a criminal record, even for relatively minor offenses like a DUI. So now I'm thinking, this evaluation might be part of a response to a notice of intent to deny, a NOID. Maybe USCIS already determined that she qualifies for the U visa, but they're considering denying her case because of the DUI. And maybe what they really want to see is evidence of rehabilitation, that she's no longer a risk to public safety. So what do? I pause the interview and I call her attorney. Now, fortunately, the attorney was available and able to speak with me right away. This doesn't always happen. So I explain what's going on, and he says, oh, yeah, this is in response to annoyed. We want to demonstrate her rehabilitation. Well, that would have been helpful to know when the evaluation was first scheduled. So now I have to shift gears completely, right? Because this isn't about the trauma she experienced from the crime anymore. That's already been documented with the police report, her declaration, and whatever other evidence the attorney submitted. Now, this evaluation is about whether she's shown rehabilitation since her DUI arrest, which means I'm no longer looking to assess trauma symptoms. I'm now focusing on entirely different referral questions. And in this case, now I need to evaluate for things like substance use history and current functioning, her insight into the DUI and what led up to it, her level of remorse and accountability, any treatment she's referred, like therapy or AA or rehab, the risk of reoffending. And I'm also, of course, looking at her personality structure, right? So is she impulsive? Does she think things through? Can she regulate her emotions? Any stressors or vulnerabilities that may have contributed at the time. So now I'm looking at tools like substance abuse screeners, maybe the MMPI to get a more comprehensive look at her personality functioning, possibly a clinical interview focused on moral reasoning, insight, coping strategies. So kind of like a complete 180 from where we started. So why am I telling you this? Because I want to highlight just how important it is to have at least some basic knowledge of immigration processes when you're doing this work. Had I not caught this, I would have written a report entirely focused on the impact of the crime and completely ignored the DUI. My report would, in that case, have been probably useless. She would have taken that to the attorney, and the attorney would have said, no, the psychologist didn't even mention the DUI. We can't use this. And now they're scrambling. The NOID is due next week, so the client has to come back, do another evaluation, pay a rush fee, and that's assuming that they're lucky enough that, one, there's still time to submit the response, because a lot of people leave this for last minute, and two, that we actually have availability and can produce a report in just a few days. The alternative is that they miss the deadline and they can't submit the necessary evidence, and then USCIS denies the case. So 10 years of waiting for nothing. So here's the takeaway. These things happen. And if you've been doing this work for any amount of time, chances are you've had a moment like this, or you will. The good news is that a lot of these situations are preventable, not because we can predict every detail, but because we can be proactive in understanding the legal landscape that we're working in. These evaluations don't exist in a vacuum. They're part of a legal process. And knowing that process, even just the basics, makes us better clinicians. I don't say this to preach or assume that you don't already know it. If you're here listening to a podcast like this, you probably do care deeply and already have some solid knowledge. But immigration law is complex. It changes. It varies by case. And even experienced clinicians can get tripped up if we don't stay sharp. That's why training matters. Not just a one-time training, but ongoing learning. Talking with attorneys, attending workshops, seeking consultation when you're not sure. That's not a sign of inexperience. That's just what's ethical, what thoughtful practice looks like. We owe it to our clients to get this right, because sometimes a single sentence in our report or the absence of one can change the outcome of an entire case. So stay curious, stay humble, keep learning. We're in this together. Remember, I have monthly consultation groups. Thanks for being here, and I will talk to you next time. I appreciate you spending time with me today. Make sure to subscribe so you don't miss the next one. And if this episode helped you, share it with a friend. See you in the next episode.